Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand property and property law. We cover 4 questions in this series, and today we are covering the 4th, which is holding property. And we all hold property subject to the takings clause of the Fifth Amendment, which says that nor shall private property be taken for public use without just compensation. So that phrase be taken, some people think that must be satisfied by a physical taking, but as we discuss in other videos, that's not necessarily the case. Physical takings are primarily exercised through a process called eminent domain. And again, we consider eminent domain in other videos. When government has exercised eminent domain, it's pretty simple to figure out that a taking has occurred. It's government declaring to the world that they are actively trying to acquire your property. So this is what we call a condemnation, pure and simple. But there's another dimension of that phrase be taken, and that's what we call regulatory takings. You might also call these indirect takings. They occur when government enacts a regulation that imposes a burden on a property interest that is compensable pursuant to the Fifth Amendment of the Constitution. By regulation, what do we mean? That could mean a state statute, a local ordinance, an administrative agency regulation, or even government decisions that enforce or administer these types of regulations. So when a property owner alleges a regulatory taking has occurred, they will style their suit as an inverse condemnation claim. Essentially, the claim is that government regulation has so interfered with the property interest that the property interest has effectively been condemned by government. In claiming an injury in takings lawsuits, most property owners allege a denial of some or all economically viable use. However, there are also cases involving physical occupation or physical taking by regulation, like the Loretto case we discuss in another video. So as you can see in that video, the Loretto case establishes a bright line rule about such physical occupations. Because of that, I sometimes conceptually group them with the eminent domain cases. In the eminent domain cases, once the facts are established, you deal with public use, you deal with public compensation, deal with just compensation rather, and the same is true for regulatory takings cases. So again, regulatory takings cases almost always involve someone alleging the denial of some or all economically viable use. Lots of property owners find it difficult to actually prove that loss. And those are the kinds of questions that regulatory takings cases consider. With that broad overview of the topic, we have a lot more to cover in other videos, so I will leave it there. I'd love to connect with you on Twitter or through my website where you can sign up to my mailing list, and I will see you next time.